Good afternoon to everyone, and thank you for attending this webinar in the context of Mission for Water project. My name is Filippo Silipigni, and I am a senior project manager in Fondazione Politecnico di Milano. That is the University Foundation of Politecnico. The goal of this of my speech will be here about to raise awareness on IP and patent documents as a strategic tool to drive green innovation, and I'm going to share with you some notions about intellectual property, the essence of patents and patent documents, and finally I will spend a few words about intellectual property and green technologies, and only a few insights. I want to start my speech trying to be very practical. And if we search in the web for and type in Google for washing machines and microplastic filters, we retrieve some solutions, some products like the ones here showed. And I think that it is intuitively to ask to ourselves some questions, such as how do these solutions work, it is possible to have a detailed description of the technical functioning of these products rather than market information. Do they work? So, what is the essence of the functioning for these products, and what is the mechanism to catch microplastics or microfibers? And if I want to, if I am interested in some of these solutions, and I want to start a commercial partnership, who is the owner of such a product? Another question could be, may I copy them? So, is there any constraint on using these solutions, these products? And finally, is there any other solutions related to this topic? In the next months, are going to appear in the market new products. So, what are the emerging trends on the emerging solutions on this topic? Let's try to see how the intellectual property system can provide some insights on these questions. Let's start with the definition of intellectual property. We mean all the creations of human mind, and they typically are divided into two groups. The first group is related to copyright and related rights, so human creations in the sector of artistic world, and we collect poems, music, literature works, but also softwares such as algorithms and similar. The other group is related to the creative works in the technical context, and we talk about industrial property rights. And here we can find, for example, patents for invention right, so a novel and the original solutions to a technical problem, trademarks that are distinctive signs to identifying products, services, and processes, industrial designs that are the legal rights that protect the shape, the aesthetic appearance of products and manufactures, and trade secrets, and so on. And beside this classification, it is worth to mention that it is possible to classify intellectual property rights also according to the ways of acquisition. So, briefly, we have registered IP rights, such as patents for invention. And in this case, in this group, the inventor, the creator, has no rights until they make a registration. So the IP right is acquired at the end of an administrative procedure, and typically the owner needs to pay taxes. Then we have unregistered IP rights, such as the copyright, and they come into existence automatically. And the registration is optional, so also costs are an option. And finally, there are also IP rights that are acquired using other ways, such as know-how and industrial secrets. And this is to say that obviously for registered IP rights, it is they are public, and it is in general easy to understand if on a target product they are present or not. For unregistered IP rights and know-how or industrial secrets, it is not so direct to understand if to identify if on a selected product process is protected by such IP rights. And why intellectual property is so important? There are some evidences about this. First of all, intellectual property rights are able to protect intangible assets, very important in the today knowledge economy. And so a small firm with few employees can be in any case of a valuable firm thanks to thanks to his IP portfolio. Intellectual property rights are able to a strong portfolio, let's say, a strong portfolio is able to attract investors, is able to protect your R&D results, so can be a way to ensure the protection for your innovative projects, and can protect you by other that can that may copy your results. Another another item is the following, that intellectual property rights can protect startups and small innovative firms from big companies, and the IP rights system can be a strong barrier for counterfeiting actions. And finally, we can mention that intellectual property rights can ensure the return of your investments through the concept of licenses or cross-licensing, supporting the ability of the owners to make some commercial partnerships. Definitely, intellectual property rights ensure consumers about the quality and the authenticity of your products. So there are many items that stress the importance of intellectual property. To conclude this part, I can show you an example of IP rights found in a products of everyday life. And among the solutions we can find in internet, we can retrieve, for example, this washing machine designed by Vestel, a Turkish company that produce household appliances, and they suggested a microfiber filter installed in the door of the washing machines. And in this product, for example, we can find obviously trademarks to stress, to point out the quality of the brand of the products, the authenticity of this solution. But we can also find some industrial design to protect the shapes, the aesthetic form of the washing machine. Eventually, we can find also some copyright related to the mechanism to control the washing machine cycle and to drive the washing machine programs. And finally, obviously, we can find some patents to protect the technical functioning of the system, how this microfiber filter is able to catch the fibers during the washing cycles. And here we have the details of this functioning. Okay, let's see the next topic. So let's focus our attention on patents for invention. We mentioned that a patent is a novel and innovative solution and original solution to a technical problem, but from the legal perspective, what is the definition? And here we can take this definition. A patent is a right granted by a government that gives its holder the ability to exclude others from making, using, offering, selling, or importing the invention covered by the patent. So it is the patent right is a legal right able to ensure a monopoly condition on the commercial use of that invention. In exchange of such a right, there are, the owner of the patent has to respect some conditions. First of all, the patent owner needs to disclose in details the invention that will be published after typically 18 months. So at the end of the life of the patent right, the invention will be public, and at the end of the right, of the legal right, the society can can use the solution disclosed in the patent document and replicate it. The patent owner needs to pay taxes, typically annual fees, to the selected country. And finally, the monopoly is limited in time and in geographical extension to the selected countries to which the owner is going to pay taxes. And so these are some limits to the patent right. And once the patent expired, the invention becomes of public domain, so that everyone is able to use that invention. It is worth to stress that not all intellectual solutions, intellectual creations can be considered patentable or can be patented. Here we have a list of concept that can not be patented. So, for example, scientific discoveries and laws of nature, mathematical formulas, rules and methods of working, for playing, for organization, informatic algorithm as such. Business methods cannot be patented. The aesthetic shape of products, they cannot be patented, but they can be protected using industrial designs, the other IP right. The presentation of information or commercial information, theoretical and medical treatments for humans and animals, and final plants, variety of plants. Obviously, pay attention that it is always possible to file a patent for products, devices, technical solutions that make use or take advantages from such scientific discoveries, methodological tools, softwares, and so on. Okay. Beside that, so we can say that there are some patentability requirements, and the first one is the patentable subject matter. We have just mentioned what is excluded from patent, and but we can add a practical example. In a few months ago, some researchers from the University of Bonn in Germany investigated the way in which some fish feed themselves using a kind of filter in the GL arc system. And they understand that this kind of fish, such as sardinas and anchovy, can use some some biological solutions in the gill arc to catch plankton's particles. And can we patent this biological strategy? Obviously, no. Why? Because it is an existing natural strategy. We can observe it. We can describe this solution, but we cannot patent this biological strategy. But we can file a patent that try to capture microfibers inspired or simulating this biological strategy. And it is what these German researchers did some years ago. They filed a patent related to a filter that simulate this biological strategy. Okay, so what are the other patentability requirements? And first of all, we have novelty. To be patentable, an invention must be new. What does it mean? The invention must not be described in the state of the art prior to the date of the filing of the patent application. And what do we mean for state of the art? They are all the information available to the public in writing or orally. And here I share with you an example. I would say a very famous example to catch your attention. Here we have a patent application from the United Kingdom, in which the inventor disclose a breathing apparatus using this very small device, and the experts at the United Kingdom office pointed out that these solutions is very, very similar to the device used by the fictitious character James Bond in the film, in the video Thunderball by United Artists. And so, according to the existence of this previous concept, this application was considered, was regarded as not new, and the application was refused. What is the second most important patentability requirement? Inventive step and non-obviousness. So your patent needs to involve an inventive step. So it must be original and not so obvious. This kind of feature, this kind of requirement cannot be so objective as the previous one. And typically here we consider a person skilled in the art, able to know the whole knowledge in the technical sector, but without any inventive ability. And if he is able to combine the existing solutions to get invention, your invention is regarded as not original, not inventive. Huh? Okay, so let's see how a patent document typically appears, and the structure of a patent document is a universal template, and we have a title page with bibliographic and bibliographic data related to the inventor, the inventor's name, applicant's name, publication date, the title, the abstract, that is a synthetic description of your invention. And obviously the patent number, able to identify strictly in a unique way your invention. Then we have a description able to in which the inventor is going to disclose in details the problem that is supposed to solve, the current state of the art, the advantages and benefits of your invention, and how your invention is going to work. And finally, we have the claims, the legal part of your patent document that defines the legal extension, the legal protection of your invention. And here, in the description, you can find, as I said, a detailed description, a detailed yes, a detailed description of your invention, so that you can reproduce that invention. Okay, so so that at the end of the legal life of your IP right, society is able to get the benefits and the advantages of that invention. Briefly, I want to remember that patent documents are classified using the International Patent Classification on scheme, and it is a hierarchical structure to order patent documents according to technological sectors, and we have 8 sections, and with classes, subclasses, groups, and subgroups, and they are very useful to identify specific product, industrial application, and so to extract also statistical analysis. I remember to conclude this part that patents are public documents, and they can be easily retrieved, I would say, using free of charge search engines such as SpaceNet, the search engine maintained and provided by the European Patent Office, and PatentScope by the World Intellectual Property Office. You can build a search string using keywords, inventor's name or applicant's name, and international patent classification codes. So let's jump to the third part, intellectual property for green technologies. I will give you only few insights about this topic. Obviously, we can stay here to talk many hours about this, but let's try to respect our time limits. So, in general, we can say that currently there is no special regime for the protection of green technologies, and the general IP system, IP framework, apply also for green technologies. However, we can mention that some IP-specific instruments and initiatives were implemented and are still implemented by intellectual property offices. Here we have a general overview, and we can focus our attention on the classification systems for green technology solutions. I need to point out this remark that currently, even if their importance, there is no single definition of green technology, and we have a definition from the European Patent Office, climate change mitigation technologies, a definition from the World Intellectual Property Organization, environmentally sound technologies, and finally, a definition by the OECD, environmentally related technologies. They are slightly similar, but there are some differences. And to find these green technologies, we have, according to each definition, we have three different systems developed to support, to facilitate the search for green patents. We have the IPC Green Inventory by the by WIPO, and it gathers 7 macro topics related to the international patent classification. Then we have the tagging scheme developed by the European Patent Office, and it is a dedicated scheme to retrieve green technologies, and it is based on the cooperative patent classification scheme used by the European Patent Office. And finally, we have the environmental tech scheme used by the OECD that merge both approaches, so IPC and CPC codes. And we focus only, due to the time, on the tagging scheme, on the tag scheme developed by the European Patent Office. Basically, we have a tag scheme that is a kind of label. As I said, each invention, each patent documents has classified using one or more international patent classification mark, and with this epsilon scheme, the European Patent Office is going to add a label, a tag, according to this definition, to what are regarded as green patents, green patent documents describing green technologies. And this label, this tag, is transversal to the different classification codes. However, Yes, we can say that, okay, so it is very easy to find the green technologies. We have an approach, a methodological approach to find them, but unfortunately, it is not so easy. Here, I share with you an example by an Italian company, SACMI. It is a multinational company that designs and manufactures machines for food and beverage, ceramics, plastics, and similar products. And some years ago, they are greatly engaged into sustainability and environmental solutions, and as you can see from their website, and they have developed a rigid packaging made of cellulose, so to be so a solution biodegradable. And here you can find the patent document disclosing their solutions and the process to produce this material. But if we check the international patent classification codes or the cooperative patent classification codes associated, linked to this patent, we can say that all the classification marks do not fall in any of the classification system for green tech. Okay, so how can we retrieve this patent document quickly? Okay, and it is a great issue. We can say that investigating each of these classification mark, we can find two classification code that remind the use of biodegradable solutions, so use of cellulose, and the following one, B65D65/4, 6, and 6, that is related to bio or photodegradable packaging materials. But as I said, all of these classification marks do not fall in any of the classification system dedicated for green technologies. So it's a pity. Finally, to conclude, the last comment is about this. There are some statistical reports related to green technologies, and they are strongly based on IPC, CPC classification marks, but as I said, with the limits we have discussed just before. And here we have an example of this report published in the 2024 by European Patent Office and the European Investment Bank. And we can say that they, from these statistics, they observed that clean tech inventions from the 2016 to 2021 increase a lot, with with a peak in the 2021. And so using patent documents and statistical analysis, it is also possible to extract some insights on emerging products, emerging inventions, trends, and which players are spending R&D activities on which directions, on which solutions. So to conclude, I can say that IP rights can first of all protect your solutions, preventing to be copied by others, and can support your R&D activities to attract investors and to establish commercial partnership. Patent documents are public, so they can be retrieved and you can extract technical, legal, market information from these documents. And it is possible, there are some methodological approaches to identify green technologies, but currently this green label it is not so highlighted in the patent system, so it is not so easy to identify green technologies. And yes, that's it, and thank you for your time.